The second main type of trust is a constructive trust. Now, a constructive trust is different from an express trust because it isn't one that the settlor has created deliberately. They haven't set out to make a trust. I think it's probably worth flagging at this juncture that the course that you are taking is written by, I think, Professor Swadling and some other professors. Now, Professor Swadling was a taught tutor while I was at Oxford. I was warned that anybody who didn't agree in their exam paper with his definition of constructive and resulting trusts would automatically get a third. I don't know how true that is. On the off chance that it wasn't a spiteful rumour, I suggest that you conform to the definitions that the subject guide gives about constructive trusts and resulting trusts. Why I have flagged this is because you may find in other textbooks that different definitions or different interpretations of the line between constructive and resulting and express trusts is a little bit different. And so you may think, oh, I have a really good grasp of what the differences between the trusts are, and then read a textbook and go, oh, I seem to have misunderstood it. You may not have misunderstood it. It may be that it's a different academic interpretation of what constructive and resulting trusts are. So if you come across something like that, let me know what you're reading, let me know what's confusing you, and if I can, I'll try and take a look and let you know if there's a sort of difference in opinion that's probably causing the issue. But it is just an opinion. There aren't really facts with this. There aren't just things. I wish I could say that there are things that you could just learn and then you've got the right answer. But here it's much more, unfortunately, nebulous in the definitions of different types of trusts. So a constructive trust is often called an implied trust. I noticed that the subject guide says specifically not to use that word, so don't use it in your exam, but a lot of other texts will use the term implied trust. An implied trust just means that the trust has come about by an operation of law as opposed to somebody has set out to create a trust. The subject guide also gives quite an interesting lens in which to view constructive trusts. I hadn't seen it before, but they give an analysis where you can categorize types of constructive trust as arising out of, I think it's wrongs or unjust enrichment or mistaken payment. I think that's quite useful, actually, and I suggest that you stick with that. So an example of a constructive trust where basically a trust has been created for reasons other than the settlor wants to create a trust. So let's say Mary has collected in the rent from the tenants and she goes to the bank to transfer the rental money to her mother, as is her duty as a trustee. And she makes a mistake and she fills out the form wrong, or she tells the bank teller the wrong thing because she's not paying attention, and she accidentally transfers the rent money to her Uncle John instead. And this is a mistaken payment trust. Mary doesn't mean to transfer the money to John. She also doesn't mean to create a trust. She's just made a mistake. But what she's done is, unlike it, when John created the Express Trust, remember, he took the ownership and he took the legal interest and he took the equitable interest and he gave the legal interest away to Mary and he gave the equitable interest away to Jane. And he could have created an Express Trust, and people often do, by splitting the ownership, taking the legal interest and keeping it for himself, and then giving the equitable interest away. Mary's done something different here, in that she's split the ownership and she's kept the equitable interest and she's given the legal interest away. She's given legal title to the money over to John. Let's say it was 500,000 shillings worth of rent. John is now trustee for the 500,000 shillings. and he needs to use those 500,000 shillings in Mary's best interest. In this case, probably the best thing and the only thing that she's going to want is for the money to be transferred back to her, but possibly John might see the money and transfer it onto his sister. And that's probably in Mary's best interest too. No one's going to argue that. And then he's given away his legal interest. So he might transfer it back to Mary, so Mary holds the legal and the equitable interest in the 500,000 shillings again, and then she needs to transfer legal title over to Jane. That was a bad way to put it. So John holds the 500,000 shillings after the mistake at the bank, and he's got the legal interest, and Mary's got the equitable interest. But the equitable interest is actually with Jane, because Jane is the one who needs to eventually get the rent. So John transfers it back to Mary. Let's say briefly she reunites the equitable and the legal interest, but the equitable interest goes straight to Jane, and then Mary needs to follow with the money so that Jane has the legal title to the money now. I hope that made sense. What's interesting about this kind of payment is that mistaken payment is also a type of resulting trust. And we're about to talk about resulting trusts.